Hi, my name's Louise Merrill. I'm a senior solicitor in the employment team at Clark's Legal. This is the third podcast in Clark's Legal's 2P in 10 podcast series. In our previous two podcasts, we discussed the two types of transfer under 2P, a business transfer and a service provision change. We then reviewed two of the key requirements for a service provision change, namely that the requirement for the client to remain the same pre and post transfer and for activities to remain fundamentally the same. This third podcast will focus on another key element of a service provision change. This is the requirement that immediately before the service provision change, there must be an organised grouping of employees situated in Great Britain, which has as its principal purpose the carrying out of the activities concerned on behalf of the client. This requirement can be broken into 4 points. There must be an organised grouping. This grouping must be situated in Great Britain, it must have the activities as its principal purpose, and it must be in place immediately before the transfer. And we'll look at each of these elements in turn. Firstly, the requirement for there to be an organised grouping. This is intended to confine 2P to situations where the transferor, i.e. the outgoing provider, has in place a team of employees that are essentially dedicated and deliberately organised to provide the activities to the client. If activities are provided by employees ad hoc without a dedicated team, then 2P will not apply. It's not sufficient that the employees in question happen to spend all of their time working for the benefit of a particular client. There must have been a deliberate decision taken by the employer to organise the employees to work for that client. Essentially, employees must be organised by reference to the requirements of the client and be identifiable as members of that client's team. By way of example, in the case of Eddie Stobart Limited and Moorman and others, there were 35 claimants all employed by Eddie Stobart. At the relevant time, the employees who worked during the day worked on a contract for a company called Vion, and employees who worked on night shifts worked on a contract for another client. The Vion contract was awarded to another provider. Eddie Stobart claimed that the 35 claimants, who were all day workers and who spent more than 50% of their time on the Vion contract, must transfer to the new provider under TUPE. The new provider did not accept this, and the individuals were left without an employer, and as usually happens in these situations, the employees then pursued claims against both Eddie Stobart and the new provider. The tribunal, and later the Employment Appeal Tribunal, which we'll refer to as the EAT going forwards, found that TUPE did not apply on the basis that there was no organised grouping. The employees spent the majority of their time on the Vion contract only by chance, as they worked during the day. Thus, the only deliberate organising that had taken place was to put them on day shifts and not to align them to the Vion contract specifically. It's important to note that case law has established that a single employee can be an organised grouping. However, this doesn't mean that an individual who works 100% of their time on a contract will always be an organised grouping. You must look at the facts and decide who has been deliberately organised in line with the client's requirements, and if there's a team that's been deliberately organised, you need to consider them as a whole. I'd like to go through the case of Seawell Limited and Seaver Freight UK Limited and another to illustrate this point, and this also leads us on to the second point that I wanted to run through with you, the requirement that the organised grouping has activities as its principal purpose. The claimant in this case worked for Seaver as part of an outbound group comprised of 8 employees. Seaver also had an inbound team. The claimant spent 100% of his time on the relevant activities, whereas the other 7 employees in the outbound team only spent between 10 and 30% of their time on the activities. When the activities were transferred to a new provider, Seaver argued that the claimant should transfer under TUPE. The tribunal agreed, reminding itself that a single employee can be an organised grouping. However, the EAT overturned this and decided that TUPE did not apply. The EAT noted that the only grouping that had been deliberately put together by SEVA were the outbound and inbound teams. The claimant was not an organised grouping himself, but part of the outbound team. Then, looking at the next part of the test, it could not be said that the activities were the outbound team's principal purpose, given that most of the team worked elsewhere for the majority of their time, and therefore TUPE did not apply. This brings us nicely onto the requirement that the activities are the principal purpose of the organised grouping. We have seen from the Sewell case that it's the principal purpose of the group that must be examined at this stage. In later podcasts, we'll cover who transfers and look at assessing whether an individual is assigned to the organised grouping, but this comes in later, and it's always important to identify the organised grouping and its principal purpose before you turn to the question of assignment. The purpose does not have to be the group's sole purpose, but it has to be its main purpose. A further point on the principal purpose test comes from the case of Tees-Esk and Ware Valleys NHS Foundation Trust and Harland. In this case, the EAT held that when determining the principal purpose of a grouping, it's relevant to consider both the employer's intention behind organising the grouping and the activities carried out immediately before the change of service provider. It recognised that the principal purpose of a grouping may change over time, and so it needs to be looked at the point of transfer. In this case, the relevant activities were the provision of care to a patient with severe learning disabilities. The care was initially provided by 27 individuals. The patient's condition gradually improved and the team caring for him reduced to 11 people, who also cared for other patients located in the same building, and in fact they spent the majority of their time doing this work for other patients. The EAT held that the principal purpose of an organised grouping of employees is fact sensitive. It found no issue with the tribunal's findings that over time the requirement for employees to care for the patient had diminished. Caring for the patient did continue to be a subsidiary purpose of the grouping, but at the point of the transfer it wasn't the principal purpose of that group. The principal purpose was providing care to the other patients. Now we'll just briefly touch on the two other requirements I mentioned earlier, namely that the organised group is situated in Great Britain and that it's in place immediately before the transfer. Given the wording, TUPE will clearly apply to transfers within Great Britain or from Great Britain. However, it will not apply to transfers into Great Britain from elsewhere. However, it's always worth noting that there may be local laws that apply in those situations, and particularly for EU countries which will adopt TUPE in some form or another. Regardless of the requirement for the organised grouping to be situated in Great Britain, a transfer can occur where some of the employees in that grouping ordinarily work outside of Great Britain. By way of example, if you have an organised grouping of 10 employees and one of the employees works from home, which is outside of Great Britain, then TUPE can still apply. However, if the whole team worked outside of Great Britain, then TUPE would not apply. Under TUPE, the organised grouping must be situated in Great Britain immediately before the transfer, but the statutory wording does not indicate whether or not the group must actually be carrying out the activities at that time. Case law has indicated that temporary cessations of work, whether this be due to a downturn in work or a contract dispute, will not necessarily prevent TUPE from applying, as the wording strictly doesn't require that employees be working immediately before the service provision change in order to be an organised grouping. Now, there may be cases where a temporary downturn in work will be sufficient to dissolve an organised grouping, but it's dependent on the facts and it won't always be the case. And just to flag, despite the wording used in TUPE, it's worth noting that the same protection applies to Northern Ireland. That brings us to the end of this podcast. I hope you found it helpful. The next podcast in the series will be focusing on the two exceptions under TUPE, where a service provision change will not be found even if the other tests for a service provision change are satisfied, i.e. a single specific event or task of short-term duration and the supply of goods for the client's own use.